start our fourth and last session with Charles Dunbar from the University and Avner Gidron from Amnesty International. So the session is entitled Human Shields, Human Rights and Military Necessity. Neve and I prepared 5 questions for Avner and Charlie.
Can I go and get my 5 questions over on my tape? I'll be right back.
So I'm going to ask the questions, and then for every question we're going to have 5 minutes each for a reply, and then we're going to open after each question another 5 minutes debate. So let's start with the first one. From Mosul in Iraq through Gaza City to Lugansk in East Ukraine, back to the East Syrian front, accusations of using human shields as an instrument of protection, coercion, or deterrence have multiplied. Why, in your view, is human shielding becoming an increasingly debated topic? And taking into account that human shielding is actually not a new phenomenon, why was the phrase hardly invoked in the past? And what are the military and legal reasons triggering the widespread recourse to this phrase within this contemporary moment?
Sure, I'll start. I think I talked briefly about developments in the law, a little bit about technology, and then about the nature of warfare. In terms of first I should thank you, Brown University, for inviting me to participate. I've really enjoyed the seminar so far. I think we should bear in mind that detailed treaty rules on the conduct of hostilities are either less than 40 years old. It's really only with the 1977 additional protocol 1 that these rules have been elaborated and codified. That's not to say that the concept of human shields and the prohibition of human shield in international humanitarian law did not exist, but it was conceptualized, I would argue, differently in the 1949 Geneva Convention. There it's really, and to a certain extent remains, in the realm of fundamental guarantees of IHL, sort of as with the prohibition of torture and inhumane treatment and medical scientific experimentation. It was conceptualized as a way of protecting certain categories of people, principally prisoners of war, and certain subcategories of civilians who are protected persons under the Fourth Geneva Convention. Now the frame changes somewhat with additional protocol 1. When you put this within the context of rules of conduct of hostilities, it's about regulating the means and methods of warfare of the parties in order to protect or minimize harm to civilians and uphold the principle of distinction. Other legal developments, of course, which we've referenced before, is the development of international criminal law, which, beginning with the ad hoc tribunals for Yugoslavia, especially, but also for Rwanda, and then the Rome Statute and the International Criminal Court has given the criminalization of war crimes some teeth beyond the national jurisdiction, and that's also been complemented by universal jurisdiction and similar forms of jurisdiction being used, including against military, militaries with advanced technology militaries. In fact, I don't know if you heard just yesterday that a court in South Africa has issued an arrest warrant for Israeli commanders who were involved in the Gaza flotilla incident. And if I'm not mistaken, I only read it very quickly. One of them was Amos Yadlin, actually. So this is, I mean, all of this means that, IHL in general, protection of civilians, issue of civilian casualties, has become much more of a publicly debated issue, and terms that used to be terms of art, including human shields, become part of the public debate, but I would argue also get either watered down or completely distorted in their meaning by the way they're often used in the media. Very briefly, developments in technology. As we know, advanced militaries are theoretically capable of much greater precision than ever before. Warfare has become more remote controlled. On the other side, we've had developments in mass media, but perhaps more importantly, social media and citizen journalism covering attacks and their aftermath. This means, anyone with a phone can broadcast and receive images of the gruesome results of strikes that kill and maim civilians. And in terms of the nature of warfare and of the battle space, I mean, there's no doubt that there's been a shift in the balance of the burden of warfare being borne by civilians. I mean, of course, it's true, as Chase and others have talked. I mean, even in the heyday of battlefield warfare between, the European great powers, you had at the same time these wars of imperial conquest and colonial wars in which it was a very different scenario, and you had huge numbers of civilians killed with impunity. Arguably, World War II sort of brought that mode of warfare to Europe, with a vengeance, and the regulation that you've seen has been a reaction of that. And you saw the vestiges of these sort of types of warfare from the colonial days in the dying days of colonialism in Algeria, Vietnam, Malaysia, Aden, Kenya, etc. I think someone's already mentioned the fact Protocol 1's recognition of as international armed conflicts, wars in which people are fighting against colonial domination and against racist regimes and exercise of the right to self-determination, was an attempt formally to bring the detailed rules on the conduct of hostilities into these arenas of conflict as well. I would say that another contemporary phenomenon related to the rhetoric of shielding, at least, is the tendency to import international humanitarian law into areas where it doesn't belong, by declaring wars on concepts such as wars on terrorism. And then trying to apply IHL and IHL concepts, including shielding, into to areas that aren't actual armed conflicts under the definition of international humanitarian law. Most obviously, there's an ongoing, as far as the U.S. is concerned, global non-international armed conflict against Al-Qaeda, the Taliban, and associated forces. I'm not saying that none of that is an armed conflict, but it's not an armed conflict because they're fighting against somebody who they say is an Al-Qaeda member or a Taliban militant. In order for it to be an armed conflict under the law, there needs to be a nexus to an actual armed conflict. As these are non-state actors, we're talking about a non-international armed conflict. That means you need a requisite threshold of actual violence as well as the organizational criteria. That means that the non-state actor against which you're fighting has to have certain features. I mean, the Taliban would clearly meet this. Al-Qaeda, not that clear. It depends when and where. So I would say all these developments together mean that governments and militaries in the West feel on the defensive about civilian casualties, in part because of domestic perception. I think that is more the case in Europe than it is in the United States, but importantly, international perception and legitimacy. They feel under greater pressure to deflect the blame for harm to civilians and civilian objects, where once they mostly just had to worry about justifying their own losses to their own populations. So what this means is that accusing the other party of wrongdoing, including, saying that these casualties happen because of shielding, becomes almost a reflex, and that's, Israel perhaps is leading the way in that, but you see that, as we've already discussed with the U.S. and the Kunduz MSF hospital strike. It's just, it can't be the fact that we did something wrong because, we're a nation that follows the law, etc. So it must be that the other party caused us, forced us to kill civilians and attack our hospital.
Thank you very much. And first thing I'd like to say is, well, I agree with what you had to say, but I want to say thank you to Brown University and all the organizers. My wife always said, you go to these places and you never say thank you. And it's on the tape and you look like an ungrateful blah, blah, blah. So, dear, I said thank you. And I also, quite honestly, I go to quite a few conferences, and oftentimes I try to find a place for my mind, some happy place for my mind to go by what's going on. That wasn't today. This was really, really interesting. I didn't agree with it. Surprise, surprise. I didn't agree with everything, but it's really interesting. I think it shows the genius of what what Nicola and Eve have done by emphasizing the interdisciplinary nature of these issues. Because they aren't just legal issues, they aren't just political issues. It brings everything together, and I think that's the only way we're going to get anywhere. So why do we hear more about human shields today? Because it works. It actually changes the behavior of militaries. But why is that? Well, I think it has a lot to do with globalization, believe it or not. Because globalization operates to raise the visibility of international law generally. Because years ago, places like China did not have law like we would understand it. But now if you want to have international commerce, you better have forums, you better have contracts. So it raises the whole idea of international law, which is why in law schools about 8 or 9, 10 years ago, international law became really popular. Because honestly, when I went to law school, there was an international law course. I'm 100% sure I didn't take it, but I don't think that there was. And what you see happen in the commercial realm often bleeds over into the military realm. So we're talking about this rise of law. The other thing, and Emmer mentioned this, you can't underestimate the impact of technology, meaning reporting technology, visual technology, social media. And what it's done, it's allowed citizen journalists, adversaries, whoever, to get inside what we call the decision cycle. In other words, they can tweet out pictures faster than government can figure out A, what the facts are, or B, what to do about them. And we saw, I don't know how much we want to talk about the Kunduz thing, but we saw that even before any facts were known, Doctors Without Borders was calling it a war crime. And the military is trained, hey, let's get the facts, let's do an investigation, but that may not work in the 21st century. But the idea of human shields, it does work. And just 3 days ago in the New York Times, there was an interesting article about the U.S. is now attacking the fuel trucks that ISIS is using to transport fuel. And as you probably know, the sale of fuel is the number one source of income for ISIS. And from a military perspective, I can tell you a lot of people are thinking, it took you 14 months to figure out that maybe you ought to go after the fuel trucks. And if you read the article, it says, well, they hadn't gone after because they were concerned about civilian casualties. What civilian casualties are they talking about? The drivers. And so before this strike, what they did is they went and they dropped leaflets, and then they did it's called a gun run, but they didn't actually shoot anything. It's just if you ever been around when a high performance airplane flies over you at 50 feet, it causes changing of clothing. It is so terrifying. So then they came back an hour later, and then they destroyed the trucks. And then they said, well, we saw the drivers running into a tent and we didn't attack. Whether all that was really required by the law of war, I would suggest not. And this is where I do disagree with you a little bit, Chase. I think that the problem with restrictive rules of engagement, when people of good intentions try to improve upon what the law of war requires, it ends up, and I'm just experimenting with this idea, of a moral hazard. Because then the military can say, we didn't attack that, we didn't cause any civilian casualties, I'm not going to be on the front page of the Washington Post. But what it doesn't say is, each time you forego a strike, that means for 14 months, people were selling oil, which financed ISIS, which caused untold misery to how many millions of people in the Middle East and Syria. Because people are trying to improve upon what international law provides. I think that we need to think, a lot of the stuff in IHL doesn't make sense to us when we first see it, but most of it was developed not by lawyers, actually, but out of the actual combat experience of nation states. And so there are things that don't, always seem to fit to us and surprise us that do have a lot of sense. And the fact of the matter is, inside the militaries, and certainly the U.S. military, but I would suggest at least NATO militaries, and especially when you start getting to Asian militaries like Japan, for example, who are hyper, don't want to be involved with anything that might be resulting in casualties, it has a huge impact. Anybody says that IHL doesn't matter, they aren't speaking from military experience, I can tell you that. Because it does really change behavior, it changes targeting aspects. And Alice raised an interesting thing about the role of lawyers, and I think you're being complimentary. I'm going to go out on a limb there on that. But here's what I found in actual experience. It is much more common to be telling a commander, no, international law doesn't prohibit that. Are you sure, Judge? Because see, they really don't want to do something, but they don't want to make the decision. They almost want the lawyers to say this or that. There have been instances like that. And so now, and I think that the role of law within the military, and especially with respect to something like human shields and civilian casualties writ large, you don't hear, honestly, inside the military, you don't hear so much discussion about human shields because it's so ingrained that the adversary is embedding himself into the civilian population for the purpose of complicating the targeting solution, that you don't actually use the term human shields. It's always about avoiding civilian casualties, or CIVCAS. CIVCAS is kind of the inside phrase. And we're seeing it more now. The hot terminology in the military these days is hybrid war. Hybrid war. And there's a good essay on it on the Lawfare blog, by the way, by some guy from the UK. University, is it University of Exeter or something like that? Yeah, young guy. Really interesting, where it's a blend. Asymmetric, as Bruce pointed out, asymmetric warfare that's been since the beginning of warfare. It has to do with using your capabilities against the adversary's weakness. In the context of human shields, what the adversary is trying to do is the center of gravity that they perceive in Western countries is adherence to the rule of law. So they want to attack and and gain an advantage that way by making it appear that this thing that we treasure is being violated by military forces. Very Clausewitzian. You know, Clausewitz talks about his remarkable trinity, and you know, it's the people, the military, and the government. Most Western militaries try to destroy the capability of the military. It's called strategy of denial. The guy at the Cornell wrote the book on. But adversaries don't try to do that. They're not trying to destroy the military capability. They're trying to separate. They want to deconstruct Clausewitz's, quote, remarkable trinity by separating the people from the government and the military. And so that's why, and it's been effective. And it's been more effective, you know, I hate to say this, but human shields are more effective than anti-aircraft guns, than jet fighters. And adversaries have gone to school with this. And who put up the Alfredo bunker? Somebody had that on one of their slides. The Alfredo bunker from the first Gulf War, I don't know if you remember what that was, but the US bombed with a precision weapon. If you looked at the photos, there's smart guys that will tell you, hey, you know, if that has that kind of antenna, that means there's this kind of radio in there, and that's a command. Well, it was bombed. What we didn't know at that time was it was being used as a bomb shelter for the families of high Iraqi officials. And so when CNN filmed that, it weren't allowed to bomb downtown Baghdad anymore. And Gordon and Traynor, in their book on the Gulf War, says it accomplished what Iraqi air defenses weren't able to accomplish. It stopped attacks in downtown Baghdad. Adversaries have gone to school with that, and they think, you know, we don't have to get an F-22. We don't have to build, you know, we don't have to buy these C-100 anti-aircraft guns. We can use this technique, so it does work. And a lot of time and energy is being spent by militaries trying to figure out how to counteract it. That's why, you ever hear this system, this sound system, where they figured out this high-pitched sound to use to disperse crowds? Because during Somalia, you know, they used to bring, you know, crowds of people down, and the fighters would be behind it. And so they wanted to use this high-pitched sound. But one of the inhibitors of the development of non-lethal and low-lethal is international law. Because is that a biological weapon? If you, for example, just on the Red Cross's blog last week, they had this long defense of tear gas, why tear gas should be prohibited under international law. It is prohibited, and why that's a good thing. I got a little rebuttal coming out about it, but if you talk to military people, you can't rationalize that to them. What do you mean? It's okay to shoot people, but we can't tear gas them? And the answer is, that's the way it is. And we talked over lunch a couple of reasons why that is, and if we want to get into that, we can talk about that later quickly.
Yeah, maybe we can open the floor for questions on this first question, the emergence. Please.
Can I go back to the lawfare issue? So I see here two positions in the lawfare warfare. So one is the ICRC, or in this case, the Amnesty International, and the other one is the military of, not military in general, the military that it has capabilities of using the laws of war in ways that introduces technology. So what I'm missing in this first round is human shields is a very contested concept in lawfare, because when you were invoking human shield, you had in mind a war crime, and you were explicit about it. When you are using a human shield, you are using it for, and correct me if I'm wrong, for trying to increase the calculation of proportionality in order to include more collateral damage within a target that has human shield.
Are you talking about the piece I wrote for this thing?
No, this just as exchange. So what I want to highlight is the contest over the terms. So when you are using it, you are using it for the purpose of pointing at a war crime, and behind it is the laws of war as it stand today. It's fine. No one should tinker with it. When I hear you using the term is, well, the laws of war are not fine because actually the other side, the adversary, is using it in ways that I don't like it because they're invoking the civilian privilege in order to decrease the number of clear targets.
Well, if that's what you heard, that's not what I meant, because I'm a strict believer in strict adherence to the core principles of the law of war. What I am not
You just said
suggesting-
that if the tanker would have been, if the civilian who's not directly participating in hostilities, who's driving.
Well, number one,
the,
we don't know that that's what the driver is. But what I'm talking
If
about
it's
is attacking the
attacking-
tankers.
Hmm?
We should have attacked the tankers 14 months ago. The
But
physical-
that doesn't go with what you're saying, because if the tankers are legitimate targets, then the drivers unfortunately get killed, but it's not illegal to attack a legitimate target to lose one
Correct,
driver.
and correct, that's like the munitions
Yeah.
workers. Yeah, you are correct, but what I'm saying is that we ought to adhere to what the law of war is. We ought not to, as a matter of policy, try to improve upon the law of war. And I'll give you another example. We've been talking
But
about.
maybe I was totally not successful in trying to point out that there are two concepts of what the law of war is in this warfare context. There's the ICRC notion and there's the military notion. And either you believe that law has one single answer or there's an inconsistency here. And I wanted to explore.
Well, I don't know that anybody's saying there are two different laws. I think that they're, with all law, and with lawyers, you can get two lawyers to agree on something, you're excellent. So there are different interpretations of what the law is, and people come from a different perspective. The ICRC is a wonderful organization. In fact, I kind of wish that the Kunduz Hospital, that Doctors Without Borders, had put a red cross on their building as Protocol 3 to the Geneva Conventions calls for, but they didn't. They put a French flag, a flag with, to many people, an indescribable or inscrutable symbol in French language, and they put it right in the middle of Afghanistan and think everybody's going to know what it means. But be that as it may.
Wait, so you're saying the U.S. didn't know that this was a hospital?
After 30 minutes of communication with them.
Oh, yeah, oh, okay, here, let me, I was thinking about, let me give you this example. If somebody called up Brown University and said, where's Charlie Dunlap? You know where he is, because someone in Brown University knows where he is. The chaos of the battlefield, and especially if you also look in the New York Times, they brought in Afghan troops and U.S. troops from outside the area, which is not a surprise since the troops that were there were forced out. And in the chaos, when people are under extreme stress and things are happening and it's dark, you know, you can't, oh, where's my GPS? That's not, half the Afghans hardly have rifles and uniforms. So the chaos of combat can create mistakes. That's why the Geneva Convention, Protocol 3, is so important, because that's why you ever see the U.S. hospital ship, the whole damn thing is painted white, and there's a 3-story high red cross on it, so there can be no confusion. If you've ever been to any of these cities in Afghanistan, every building looks the same. Or, it's kind of like in the Middle East. You ever go jogging in the Middle East? You better drop form, because you'll never find your way back, because there's no road signs, there's no anything, and if you don't speak, the local language, it can be very, very confusing. But be that as it may, the problem when you improve, like when President Obama, you gotta love him for this reason, he wanted to project concern for civilian casualties. So he announces to the world that we are not going to conduct a drone strike unless there's a near certainty of no civilians casualties. What do you think the enemy does with that? Oh, do you think that they're indifferent to that? That's why they always have civilians around. Because the president has told them that they are protected from a drone strike unless there's a near certainty of no, and that's not what international law requires. International law permits you to know absolutely 100% certain that you're going to kill civilians, so long as the military advantage is such that that civilian loss is not excessive.
Not if there is no target, as in a drone.
Well, the military advantage, that is what the
No,
target.
but a drone doesn't have a lawful target. There's no calculation there if there's no lawful target.
Yeah, well, obviously you have to have a lawful target, but
Yeah, but most drones don't have, as your
well,
presentation was-
okay.
If there's a
If
SIM
you believe what the intercept says, I can't argue with
A SIM card
that.
is not a lawful target, is it?
What?
A SIM card. I'm just,
If you believe that that's the way the targeting works, but as I mentioned before, I was sitting there thinking, does anybody really think that a SIM card is, if you make a phone call, that makes you a target? And I'm thinking,
but the numbers
evidently,
of
because
civilian-
these
civilian
are
deaths,
very
that's
erudite
we
gentlemen.
can agree on that. The number of civilian deaths, or not?
Yeah, take a look at the Bureau of Investigative Journalism, and you will see that there aren't. Even now, the guy from Amnesty who wrote the op-ed in the New York Times a couple of weeks ago, even he said, well, there are 22% of the casualties were civilian casualties. Number one, that isn't necessarily illegal, but the way they get to that number, they go back to like 2010, 2009, and so forth. But if you look at the recent years, the numbers are very, very small. But then we have to think, who is responsible for the deaths if we let that person live? Look at the UN report. The UN report for Afghanistan, for example, has consistently for the last several years, 70 to 75% of the civilian casualties were the result of anti-government elements, which means Al-Qaeda and the Taliban. So if each person you let live, then you are taking on that moral hazard. Because then you're responsible for what casualties they incur, at least from a moral sense.
Thanks. Maybe Avner, you want to respond or?
I think we should move to.
Okay, the question is related, the second question is related to this last discussion, and it's what does human shielding mean to military legal experts, and what does it mean to human rights practitioners? I know, do in other words human rights and military professionals differ in their conceptions of the practice and normative significance of human shielding? Maybe Avner, you want to respond?
Can I rephrase that question?
Okay, sure.
And after this, I won't say anything, I promise.
Don't promise. Don't promise.
No, but I won't, but, okay.
Seriously,
So
no
the
problem.
thing is that every person who operates the discourse of IHL operates under the assumption that it should not interfere with the legality or the morality of war making. And what you're doing is exactly that. And that is not different from what the shielders are doing. So in your presentation, what they are doing is they're invoking the morality or immorality or the injustice of the force, and you are doing the reverse. So what the ICRC, I'm not an ICRC person, but what someone would say is, no, this is neutral. The laws should be neutral. They should treat everyone as a neutral combatant. Whereas the shielders are saying, no, they are unlawful, and we're going to take advantage of these rules, and you're seeing the inverse, exactly the inverse. So the problem is where to go after. One is, well, you will just win because you have more power today, maybe not tomorrow, but today you will win. You meaning those powers with technology. But as we learned with you, well, I'm not sure that will be the case. And that this goes back to the very old-fashioned idea of the ICRC that I used to mock, but I think it's true. It is, we don't know what the morality of war is. And under that assumption, we can agree on certain rules. But that requires that all players do fair play. And as some who are doing human shielding are not playing fair, I think what the use of human shields discourse from the point of view of the powerful forces with technology are using is also not fair play. And
so you would believe that we need to even up the technological capabilities. So we need to give ISIS more capabilities, so it's more of an even fight, so that they can enslave more women.
Unless they're directly participating in hostilities. That's it. Either you have to decide they're civilians, they're terrorists, criminally responsible for what they do, or they're civilians unless they directly participate in hostilities. That's it.
Yeah, but the question is, do you basically agree on the same idea of human shielding? Do you feel that human rights practitioners and legal military experts conceive human shielding in the same way? And if yes, how? And if no, how?
Okay, I mean, as a human rights practitioner, I mean, I think there'll be things in common. I think, Charles and I both showed up in ties today. Neither of us is likely to reference critical theory or Foucault in our answers to these questions.
Not critique of pure reason, or the fallacy of the undistributed middle, which is actually what I thought of.
But yeah, I mean, Amnesty is a human rights organization. For the first 30 years of our existence, our mandate essentially precluded work on conduct of hostilities. I worked on one of our first reports that really looked only at IHL and conduct of hostilities, which was about the NATO bombing of Yugoslavia and what we consider to be violations of IHL in that context by NATO. At the time, a senior colleague in the legal department, only half-jokingly referred to IHL as football rules for murder. I mean, there is suspicion in human rights organizations that is very, very old about and a discomfort with IHL. I mean, that said, for 20 years we've been working increasingly on situations of armed conflict and more on IHL. And if you're talking about human shields, you have to look at IHL. I mean, I think we'd agree that, there's the definition in IHL is what you need to look at. If you take, policing, human rights situations, I mean, you could say hostage taking might be analogous, but it really isn't. I mean, the logic is completely different. Resort to lethal force in the hostage taker situation is governed by, the protect life principle. And, what you're trying to do is, basically protect people from imminent threat of death or serious injury. And, lethal force must be the least harmful means available, including in relation to the hostage taker. If you're talking about human shields, and IHL, it's completely different. You know, you're talking about, well, essentially precautions, yes, but proportionality ultimately, which is weighing the direct and concrete military advantage anticipated from an attack against the likely incidental harm to civilians and damage to civilian objects. In a policing operation, rescuing hostages, incidental harm to civilians and damage to civilians, you know, you're trying to avoid harm altogether if at all possible, whereas an attack on a military objective shielded by civilians, you know, it's this proportionality calculus. Where we might disagree is how you weigh that. And I think in another question we'll get into that more. But I think human rights practitioners are more likely to interrogate whether a situation is in fact armed conflict. If there is no armed conflict, there's no human shield. If you don't have a legitimate, and then even in an armed conflict, if the target isn't a military objective, there is no human shield. For example, in 2000, I think November 2006, I remember working on a case in Gaza, which was a commander of the Popular Resistance Committees. His house, the Israelis warned they were going to destroy his house from the air, because this was after they had redeployed, so to speak, and people rushed to the roof of the house in order to protect it from being destroyed. And I think even Human Rights Watch expressed concern this was human shielding. From our perspective, it wasn't, because the Israelis weren't even saying that this house was being used for military purposes. This was, you know, a continuation of a long tradition of punitive house demolition, basically, which was, you know, it's a family home of somebody they suspected of planning attacks against Israelis, so they were going to destroy the house, and people came in solidarity to protect the house. That's not human shields. Another example where we might disagree is on the difference between co-location and shielding. I think this is clear in sort of the classic shielding cases, the unwilling human shields. It may even be clear in the voluntary human shield scenario, but in what's been referred to today as proximity shielding, that distinction isn't entirely clear. The co-location is something that's supposed to be avoided. It's part of the precautions against the effect of attack that the defending party has to take, but it's an obligation of means. It's not an absolute prohibition, unlike human shielding. So when we look at Gaza and a lot of the incidents that Israel has said are clear-cut human shields, it's much less clear-cut to us. I think especially in Gaza, it's often hard to tell the difference between co-location and shielding, especially proximity shielding is difficult to differentiate. I mean, bear in mind, even with warnings, etc., I mean, Gazan civilians don't really have lots of options of where to go. They can't get out. I mean, you don't see, you know, refugees from Gaza when there's a war with Israel, because they can't get out. The Egyptians won't let them out, the Israelis won't let them out. Just one more point. I mean, co-location, I mean, that's a difficult issue. I look at, you know, bear in mind in, you know, even in Israel itself, where, you know, they have more options. You know, one of the biggest bases, one of the most important military bases in Israel is in the center of Tel Aviv, in a very populated, densely populated area, very expensive piece of real estate, in fact. in our experience documenting violations in the Israeli-Palestinian context, the clear-cut classic cases of human shields have been Israel using Palestinian civilians as human shields in the prior warning procedure, which led to a decision by the Supreme Court prohibiting it. But then again, in Cast Lead, we had situations where you had Israeli soldiers going into Palestinian homes in Gaza and using them as firing positions and holding Palestinian civilians in there too. I mean, I think it's one thing you can take over a place and say, this is now a military objective, but if you do that and you're using it to fire at the enemy and you're holding the civilians there, that's human shielding.
Well, I think we're pretty close on the same sheet as to what the law is. And honestly, one of the great benefits of this particular conference to me personally is I learned that I don't know as much as I thought I knew about what Israel's doing in the whole Gaza war and some of the other things that have been brought to my attention. But getting back to the law, as Abner said, the law of war is lex specialis, and it displaces human rights law in those areas that it applies. You can have, and I believe, you can have the application of international human rights law and the law of war in the same area. For example, if a soldier steals something from a local, international human rights law applies. That's not a law of war issue. But in terms of human shields, and I do think that there's a danger of conflating the general issue of civilian casualties with the specific issue of human shields, because human shields implies that the humans are being used as a means or method of warfare in some way. I do think that when we, in terms of I think the ICRC is very right in that they do not take an ideological view, because if they did, it would unravel the whole scheme of international law, the law of war. In other words, every country thinks that they have the moral high ground. You might remember, we talked about this during lunch, German soldiers during World War II, their belt buckle, Gott mit uns, God is with us. That was their mindset. I'm not talking about the SS, I'm talking about the Wehrmacht, the typical German soldier. And the ICRC, the wisdom of the Geneva Conventions is that they are, so in other words, there is no principle under international law of a fair fight, in the sense of you have to have both sides have equal capability of winning. And that's why when part of the problem when we start using words like proportionality with respect to Gaza, I invite people to read Lori Blanks' post on proportionality, because it can get very confused. And just because one side wins in a lopsided way, that doesn't mean that the international law has been implicated in some way, because you can win overwhelmingly. You can have 100-0. In fact, most military organizations aim to have 100-0. I can tell you in the United States Air Force, we intended to destroy every enemy aircraft with 0 losses. And a lot of taxpayer money has gone towards that, and oh, by the way, it's been pretty successful. But because if you don't do that, and this is the objection that one of the objections that the U.S. had to Protocol 2 of the Geneva Conventions, which is supposed to be non-international armed conflicts, because in there they granted combatant status based on the ideology of the non-state actor. Remember, it's fighting against colonial oppression and all that sort of thing. Because people can say all sorts of different things about what they're fighting for, and everybody thinks that they're fighting for truth, justice, and not the American way, but the good way. And so I think it has to be ideologically neutral, otherwise states it would unravel everything. It has to be. So you can't set up a system where, we like this little group, and geez, they have to put innocent or put human beings at risk because otherwise they're not going to win. You can't have that. The civilians, it's an untenable position to say it's okay to use civilians as human shields if you're a little group of neo-Nazis who's trying to overthrow the German government. That somehow they need to have a shot at doing that. That's not gonna fly and shouldn't fly with nations. And if nations don't
So
believe,
the neo-Nazis should be killed.
sorry?
I don't understand the example of the neo-Nazis. Because precisely brings the ideology.
Because you seem, and maybe I'm wrong, I thought you were saying that the inferior militarily capable ought to be able to use human shields to protect themselves because they don't have the technology that, say, the German government has that they could bring to
No, what I mean is that if the neo-Nazis are not directly participating in hostilities, they're civilians. That's the
Well, what we're talking about is in the context of an armed conflict, because otherwise, as
That's what I'm
Abner
talking
said,
about.
that we're in the International Human Rights Law, it's just a criminal activity. But if you're talking about a group that's trying to overthrow a government or something, and we're into the realm of the law of war, as opposed to international human rights law or law enforcement, then you can't have a scheme by which you justify human shields. You can't take people and use them that way. It's not going to be accepted by nations, no matter how worthy somebody might think that little particular group is, because that's not going to be accepted by nations, nor should it be.
So there are 3 questions. Bruce, Neve, Lisa.
Yeah, I mean, I think to your last point, I don't think there's really any disagreement that human shields are illegal and that they shouldn't be used. The question comes is if they're used, what are the responsibilities of the attackers? Now, when you mentioned 100 to nothing, as long as it's combatants versus combatants, like the Gulf War, not over the cities, but the Gulf War in the desert, that's fair game, right? Combatants, if you lose none and they lose 100, that's war. But there are 2 indicators. We call the civilian casualty ratio, which is looking at the percentage of casualties that are civilian. Then there's something called the risk transfer ratio, which is how many of your soldiers die versus how many civilians die. Then you're looking at something other than this game of combatants versus combatants. Just to give an example, if NATO lost 0 troops in the war against Serbia, and there were between 500 and 1,500 Serbian civilians killed, depending on, there's not a definitive, it does give an indication that NATO is not at risk. And so the loss of 500 to 1,500 civilians seems high compared to the risk that they had. And then if you compare the number, let's say, 3,000 people are killed. If 1,000 of them are civilians, okay, I mean, there is no exact number, but 33% when you're following the rules of war is pretty high. It's not high if you're dealing with countries that deliberately target civilians, but again, proportionality, I know it's
Well, those ratios are irrelevant. They don't exist in the law of war.
No, they don't.
Because what the law of war is concerned about is what is the military advantage. And so, for example, if you have a guy in an apartment house filled with, say, 1,000 people, and the only person you want to kill, could there be a justification for that? Yes, and I'll tell you why. If he's sitting there with a button that's going to set off a nuclear weapon in the middle of New York City. So military commanders have to make those kinds of decisions all the time.
Okay, but that's an extreme example. What's more likely is if you have what's more likely in practice. I mean, you have an apartment building. There are 5 Taliban commanders, or not even commanders, 5 Taliban. They're in there, and there's 20 civilians in the building. The question is, do you have to hit it at that particular moment? And at what point do you say, because if you say military advantage, yes, you can leave it to what's called the reasonable military commander, but at a certain point, you can claim a military advantage to anything. So there's got to be some semblance of balance. That's the idea. You're right. These ratios mean something from a political perspective, which is what I'm working with.
But here's the thing.
Yeah.
You do have to take reasonable precautions. So if there is another way of accomplishing that, but on the other hand, you know how many people 5 Taliban can kill? a hell of a lot more than 20, and they have. So military commanders have to make those determinations. You're talking about a group of people that's responsible for over 75% of the civilian casualties in Afghanistan. So each time a commander forgoes it, and they forego a lot of strikes, then those guys live to go out and kill not other combatants rarely. They rarely take, how often do you think they take on the
No, they, obviously they deliberately target.
Maybe, yeah,
Okay,
there are two
But that's a fact.
Is it-
question.
is it-
That's a fact.
No, I'm not the.
But let's do,
There are people
let's
with-
just one suggestion. Let's, the people that wanna ask questions, including myself, will ask. Or will intervene or comment, and then both of you will just write down what we're saying, okay?
Okay, but there is something connected to the last question.
Can I read?
Yeah, sure.
Okay, so from what I take from this discussion, I missed 2 sessions, so I might be putting it. But the basic problem is that there is no definition of military advantage, no real definition. What is a military advantage? Do you compare it to a specific attack and a specific target you're engaging with, or do you see it in a broader operational structure? And that's the thing with IHL. IHL is a powerful tool, but at the same time, it leaves so much room for interpretation for states that it easily becomes an instrument of justification and not a neutral standard. And that is, okay, I'm going to make strong claim here, but that's in my opinion why as lawyers, I'm trained as a lawyer, we should also look at the political side of things. We can never understand conflicts and standards if we only look at IHL as it is. It is subject to constant reinterpretation by states, by actors, and that was my point.
So actually my question
connected to-
is a specific question, but assumes what's your name?
Sama.
Sarah says, when you talk about co-location and distinguish it from human shielding, that's exactly what we talk about in apparatus of discrimination. How it's clear to me that Amnesty can call it co-location and that Charlie can call it human shielding. And both of you guys are referring to the same law, which is exactly what you're saying. So how do you actually make this distinction between co-location and human shielding? Lisa,
Collecting questions again. So maybe this also follows on both of these. You know, I think that one of the important issues to think about is the context within which the concept of human shields gets invoked in terms of like the interpretation, so that these the lawyerly, desire to interpret IHL as though if you do it right, it gives a correct answer under certain circumstances. And I think that the questions of particularly, at least what I was stressing, is the way in which, for example, the Israelis have reinterpreted in 2 specific ways, subsequently, the concept of human shields, is the extent that they actually deprive civilians in the situation that Bruce was describing as the proximate context of their civilian status. I mean, they essentially say they are de facto, they are deliberately targetable as such on the grounds that, and then those that might, within that same proximity, who might not on some abstracted notion actually be civilians by the Israeli point of view, then they are collateral damage, but the fault lies with targeting operations. And so the question, or just to get a response, is that we, should be thinking about how contemporary debates about human shielding are lending themselves to different understandings of where civilianness ends. And I would say maybe just analogously, one can find the same thing in the US military rhetoric of drone strikes. Everybody's a combatant, unless they're posthumously proven to be civilians after the fact. It's a kind of similar erasure of civilianness because you want to bomb.
Jason, Nina.
Yeah, I'm curious if either of you find that questions of use in bello, including human shields, but other, end up serving as proxies for questions and criticisms of strategy and jus ad bellum. And what happens, I mean, if you see this happening, as a result, do things get obscured? And I mean, it's okay, Avner Gidron, if you give an answer, just your personal point of view, not the point of view of Amnesty International, which confines itself generally to only jus in bello, along with other human rights NGOs.
Can you give us a little more on that, Chase, exactly what you mean?
Well, there was an interesting exchange between Samuel Moyne and David Cole in Just Security blog, and before that in Dissent magazine, where Moyne pointed out that many liberals and Democrats who were against the Iraq War, rather than attacking or criticizing it full on and presenting plans for how to withdraw, confined themselves to criticizing the way in which the Bush-Cheney war in Iraq and war on terror more generally was being conducted. Civil libertarian criticisms of the how of the war, the renditions, Guantanamo, without looking so much at the bigger questions. And are there liabilities to that coy and clever use of jus in bello as a stand-in for the strategic question?
Nina?
Yeah, I just want to sort of raise the issue of legality versus legitimacy. I mean, it seems to me that, the issue of involuntary human shields is, that's clearly illegal, but the issue of voluntary human shields that people running to the roofs of buildings is much more problematic. And we have to ask sort of how does law change? And we have cases where the powerful, in the Kosovo War, going to war against Kosovo, we argued, the West, that, well, it wasn't legal, but it was legitimate, right? Because it was conducted without a Security Council authorization. The killing of Gaddafi, I think, is a similar kind of case where...
Well, that had UN authorization.
Yeah, without UN authorization.
No, that had UN authorization.
The killing of Gaddafi, no.
No, the killing wasn't, but the intervention was.
No, it was civilian protection mission that clearly violated the mandate.
Yeah, it did.
And so I think any pure legal analysis would have to say that was illegal, but it was legitimate and it was approved by. So here you have the powerful who are allowed to argue that, well, the legality is not crystal clear, but it's legitimate. And so it seems to me you have possibly a case on the other side here where the defenders, the weaker party, feels distinctly at a disadvantage. And so an attempt to level the playing field is arguing, it's okay, so it's not, human shields are not perhaps perfectly legal, but they're legitimate in the context of this deeply, deeply asymmetrical conflict. And I wonder if at some level those arguments don't resonate, right?
Well,
And that's part of the challenge, and why you get this, I mean, it seems to me your argument is that what we're getting today is social enforcement of standards that are higher than the actual laws, right?
I think for the Western militaries, but let me get back to your original use. The propriety of jus ad bellum has no relationship to use in bellum.
Yeah, so so the Gaddafi case is
and the reason being is exactly what I said before, lots of people think they're justified in using force. And you're right, that is political. The political world will make the ultimate decision on jus ad bellum. I think you raise a good point. We get asked this a lot. I call it the cookbook question that you have on what is military advantage, because military commanders ask that too. Because they want the lawyer to make what is essentially a military judgment. That's why our courts in the U.S. don't want to get involved, because they say, we don't have the competence. That's a military judgment. And as a military lawyer, you tell the commander, you determine what the military advantage is. But then you have to ask yourself, if you don't like that definition, what definition would you want? And I think that's the problem that was had when they were I think the world would love to have a better definition, but when you start thinking about it, well, what is going to be, because there's so many different facts. And I'll tell you, when you get in with operators, with military people, they want to try to think about every possible military factual situation, and then you give them a legal reading so that and you can't do that, because I can tell you the first thing that they get is is going to be something that wasn't in that 100 scenarios that you went through. They have to internalize it, and what people need to do is they have to make decisions and they have to be accountable for them, and they have to be able to explain why they were reasonable in the circumstances. But this is not unique to IHL. Take a look at criminal law. Take a look at what criminal law says about conspiracy. It doesn't even tell you what an overt act is. It's whatever the prosecutor decides it is and whatever the prosecutor can prove. It's a little bit of the nature, most law will have generalized statements like that. And that, for example, in US military law, it is a crime to conduct unbecoming an officer and a gentleman is a crime. It went to the Supreme Court on the issue, void for vagueness. How are people supposed to know in advance exactly what it is? And the answer that the US Supreme Court gave is kind of like they did in pornography. Military people know it when they see it. And, you know, because there is no way of describing every sort of situation. I think sometimes we as lawyers, and lawyers can be, are you already a lawyer?
Yes, but not predictive.
But, you know, we sometimes think, well, we want a very specific, a codal system. That's not the way the real world works. There are too many permutations of facts. And sometimes, honestly, you have to push commanders to make a judgment. You need to make a decision, and you're going to be held accountable for it. So you need to start thinking, what is your reason for that? Even if you're not held accountable in a court of law, you're going to be held accountable in the court of world opinion. So you better, especially this comes up a lot with dual use targets, meaning something that can be used by civilians and military alike. You better come up with an answer. Well, is that required? Well, no, the law doesn't require it, but you're going to have, people are going to be asking this, and in today's world, you're going to have to be able to explain it. And that's why being a commander in the modern 21st century is a very hard job, because, you know, the system will throw you under the bus when things go wrong. Watch what happens with this Kunduz thing. Somebody's going to be thrown under the bus. But do you remember what President Reagan said? Remember at the Beirut bombing when all those guys were killed? He said, I'm accountable. He didn't throw the military commanders under the bus, which he could have, because remember, the rules of engagement at that time said, well, we don't want you loading your gun because it might go off and kill somebody. Well, then, of course, the suicide bombers blasted through the checkpoint before these guys could get their guns loaded. So, bad judgment by the military commander, but the president took the responsibility. And, you know, that's our conundrum here. And like with the human shields, you know, I think there is, and this is going to haunt me with these guys here. There is an argument that you have to use the proportionality analysis. But the other side of it is the principle in international law that you don't allow someone to benefit from illegality. Because in theory, taking to the extreme, you could have a military force that is totally invulnerable. Because you could have if you had enough human shields, you'd surround each one of your soldiers with 5 people and you'd attack. And in theory, then you wouldn't be able to strike back. Will that happen? Unlikely. But we lawyers always think of the worst possible case scenario, and sometimes we're right, actually, unfortunately. And so in the real world, the way
So
it
killing human
operates-
shields is a form of prevention?
Sorry?
Killing human shields is a form of prevention?
The idea is that you
Of war.
you cannot allow an adversary to successfully turn illegality into an international norm. And that's the theory of, I think, the way the manual's written. I don't think that's the right, and as you see my piece, I try to go a little bit different direction. But what you said, that's a legitimate way, and that's the way it would work in the real world. In the real world, I think most operations, you would do a proportionality analysis, and you do look for other ways of conducting the attack. And I think that's the obligation when we talk about feasibility. And let me give you one example from the first Gulf War. You remember the Ziggurat of Ur? You remember when the Iraqis drag their planes. The Ziggurat Burr is like on the UNESCO thing. They drag their planes right next to it. Could you have attacked it? Maybe. 2 legitimate fighter planes. But, and this is why it's so important for lawyers, especially, to know a lot about military equipment, strategies, and so forth. If you know anything about airplanes, and it's dragged across the desert, you will not get a pilot to get into that airplane and try to fly it. Because that little bit, the engine, unless you break down the whole engine and clean it very carefully. And so, hypothetically, what happened is they looked for a bridge that would get those planes back to the airfield. And let's just say there isn't a bridge there, or there wasn't a bridge there. And that's the kind of thing that happens in the real world, because if nothing else, people know, or military people know that, or they believe that they're not going to be defended, even if they do something legal, if it doesn't look right. And so, as we were talking about international law, that's the baseline. You know, that's not, just because it's legal, it's not meaning it's right. There's a morality that goes above that, and there's a wisdom, a political wisdom that goes above it. This is just the lowest common denominator that the international community could settle on. It doesn't mean everything is moral and right.
Maybe you want to
Sure,
respond to
thank you.
that?
Just quickly on Bruce's point about the ratios. I mean, I think if a ratio between your own military casualties and civilian casualties, you know, what that can, it's not evidence of anything in and of itself, but if it indicates that you're putting such a premium on, you know, protecting your own troops, that you're foregoing feasible precautions, then, you know, that is
I agree with that.
a problem. And, you know, arguably, you may not agree with this, NATO had to change from flying 30,000 feet to coming down a bit lower, because in the 1999 conflict, I think they were hitting some refugee and IDP columns because they weren't necessarily doing all they could to identify or distinguish between that. He's got a 2-finger on this one, I think.
Here's the thing, I understand what you're saying, but the fact of the matter is most modern planes are not targeting by looking out the window, and they have other systems that are optimized at a higher altitude. And so you think, well, they're doing that to protect themselves. Let's assume that's the case. It really isn't. It's to optimize how the weapons work. But if you're flying low and you're giving the enemy to shoot you down, you know what that does? You know how much a plane weighs? 30 tons. That means you have a 30-ton bomb uncontrolled in some area that can cause huge civilian casualties.
But that situation rarely comes up because, I mean, you know this, the first week or two of any war with a country like the United States or Israel is destroying their integrated anti-aircraft system.
But that's why they don't fly at 500 feet.
Right, but I mean, in NATO, the example you're giving, or that you had given, Serbia really at that point didn't have the capabilities of shooting down NATO planes, not in any.
They shot down the F-117.
They shot down one plane, yeah.
And they shot down.
And they didn't kill it. But,
Okay, just quickly to move on to Neve's question about the distinction between co-location and shielding. I mean, that is a difficult one, and you know, you have to look at the facts of each situation, but I would say it has to come down to intent, really. And it's difficult to make that call without some, you know, clear indication of intent. The ICRC, how the ICRC puts it in its customary IHL study, they say the use of human shields requires an intentional co-location of military objectives and civilians or persons of the combat with the specific intent of trying to prevent the targeting of those military objectives. Now, and that's because you're talking about a serious violation, potentially a war crime. It's, you know, if you look at the jurisprudence of the ICTY tribunal, every case that was successfully prosecuted is clear-cut human shielding, taking POWs or civilians and, you know, forcibly holding them in a situation because you're trying to prevent your own forces or a particular piece of military equipment from being from being targeted. The fuzzier forms of shielding are, it's much more difficult to tell. I mean, I don't doubt that there were cases of actual shielding, including in Gaza by Hamas. It's certainly true that ammunition was found stored in, though it was empty spools, for example. So, I think that Hamas was using part of a hospital for interrogating suspected collaborators. That's certainly not good practice. But generally, I think you do have to look at intent if you're going to talk about actual human shielding as opposed to co-location.
And I agree with that, and I think we both agree, you can never target a human shield.
Yeah.
That can't be the target. It has to be the military, the military objective is the only thing you can't target human shields under any circumstance. They may be killed in your effort to get at the military objective, but that's different. And just one last thing on the 500. You can't, when a guy's flying at 500 feet, he's not looking out the window. He's trying to get the airplane in because he's going to hit the mountain.
Yeah, I have to ask you the next question.
Okay.
I mean, I don't know if it's going to be the last.
Yeah.
Well, it's something related to something we discussed, but I want you to enter more in depth in that realm. So basically, the new United States law for manual states the following about human shields, and I quote: "The party that employs human shields in an attempt to shield military objectives from attack assumes responsibility for their injury, provided that the attacker takes feasible precautions in conducting its attack. If the proportionality rule were interpreted to permit the use of human shields to prohibit attacks, such an interpretation would perversely encourage the use of human shields and allow violations by the defending force to increase the legal obligations on the attacking force." End quote. Hence, the manual, in line with international law, does two things. On the one hand, it prohibits, as we said, the transformation of civilians into human shields, while on the other, it allows military forces to attack targets that are protected by human shields, provided they take all feasible precautions. What do feasible precautions mean? Could you offer empirical examples of the kind of feasible precautions that should be taken when targeting areas in which there are human shields? And in your view, should proportionality be applied differently, or does proportionality operate differently in human shielding areas than it does in civilian areas?
Okay. On precautions, these are really the precautions that are set out in Protocol 1 in Article 57 and are part of customary IHL, including in non-international armed conflict. The overall principle being that, in the conduct of military operations, constant care shall be taken to spare civilian populations, civilians and civilian objects. And that note is about military operations, which is wider than just attacks. Then it gives precautions in the actual attack. For planners, as we've said, you can't have human shields if there's no military objective. The first precaution is to do everything feasible to verify that it is a military objective. If it isn't, it should not be attacked. In reference to this precaution, it's important to remember another provision of Protocol 1, Article 52, Paragraph 3. In case of doubt whether an object which is normally dedicated to civilian purposes, such as a place of worship, house, or dwelling or a school is being used to make an effective contribution to military action, it shall be presumed not to be so used. So if there's doubt that something that is normally a civilian object is being used for military purposes, presume that it isn't. Next, the planner has to choose the means and methods that will minimize harm to civilians and civilian objects. This has to do with the choice of weapon, how it's delivered, and, for example, like what time, when to attack, when not to attack. And you have to refrain from targeting an objective that would cause disproportionate harm to civilians and civilian objects. Another precaution, if destroying any of several possible targets would give a similar military advantage, you have to choose the one that is least likely to endanger civilians. In reality, that's most likely to be if it's about disrupting, say, communications and something like that. So that'd be an example where even if it was legitimate, for example, the example of Serbia, radio and television in Belgrade, if it is the fact that somehow not that it was being used for military communications, surely they could have chosen a way of disrupting it that would have been less harmful than targeting the headquarters and killing, I think, 16 civilians. When carrying out the attack, so now this is not the planner, this is people who are actually carrying out the attack. If it becomes apparent that the target is civilian or that attacking it would be disproportionate, because, for example, it's been surrounded by civilians or human shields, if you will, the attack must be canceled if it be disproportionate. And effective advance warning has to be given unless circumstances do not permit. And finally, the fact that an attacking party has taken the feasible precautions does not then mean that they can go ahead and attack civilians. So if you give effective warning to to people, civilians in the vicinity, whether they're human shields or not, they don't stop being civilians because you're giving them effective warning and they haven't left. And yeah, so no provision of this article may be construed as authorizing any attacks against the civilian population, civilians or civilian objects. So in a shielding situation, if an attacking party has taken these feasible precautions, they will be aware of the presence of civilians in the immediate vicinity of a targeted objective. And to a commander, normally, a reasonable commander, the presence of a large number of civilians, whether or not they are human shields, would weigh heavily in favor of suspending an attack until it can be carried out at a time and in a manner that will not put as many civilians at risk. Now, there's always going to be, an argument about exceptionally military objectives whose neutralization would offer an extraordinarily high military advantage and, for example, a time-sensitive opportunity to attack the enemy's high command. In that case, it's still about proportionality, but you've got a very, very high military advantage, and, it might be that you would have to calculate that, a certain number of civilian losses would be acceptable, so to speak. Now,
What's your
military. I mean, it's an impossible question.
It's not an arithmetic calculation.
Yeah, and there's also, first of all, military necessity, that's built into every rule of IHL. So you can't argue military necessity as a reason to ignore a rule. So if you look at all of these precautions and you look at a situation of, at least the presence of civilians, whether they're shielding or not, you have to look also at the military necessity, because, an example, again, this time from, say, Israel's war in Lebanon against Hezbollah, if you keep on attacking an area from which rockets have been launched, or and the pattern has shown that by the time you strike the place where the rocket is gone, the team that launched the rocket and moved the rocket launching pad, etc., and yet you're still endangering civilians. That's not, there's no real military advantage you're gaining. That's just, ultimately punishing the civilians in the area. So, that's something that, especially once the pattern is clear, you shouldn't be doing. Now, the important question you raised about voluntary versus involuntary. Ordinarily, I think it would be very difficult for an attacker to determine whether a shield is voluntary, what the motives of the civilians are. And as you know, it's not just voluntary versus involuntary. Are they being, physically restrained and kept there? I mean, you might be able to tell that.
So
are they under moral pressure?
Only from the side of the attacker? Before you answered me and said intent, it's about intent. And
Yeah.
now you're telling me, well, the intent of the shield, the human shield,
It's not for the
is
target.
not important because we can't determine that intent.
What? No. The party that is, if it's using human shields, it's only using human shields if it has the intent. If it's just co-location, it's not. And that goes to whether it's committing a violation of a war crime. But from the perspective of the attacking party,
But from the perspective of the shield.
well, I mean, of course it matters to the shield. I mean,
But you're saying the attacker cannot know the intent of the shield,
I
if
mean, they
he's
sometimes
voluntary
will
or
know.
not.
I mean, they will
Right?
sometimes know, but to
But
me,
most
it's
often
very
they
hard
won't.
to.
I agree with you.
They can publicize.
But,
I mean-
but they can, but let's say they don't. We can't know, really. I mean, I'm not arguing that, but how, I think the same can be said about the attacker. We really can't know the intent of the attacker. He can utter the intent, but we don't know if the intent is true.
But intent is an element of a war crime,
Right.
because
No.
accidents are not. So the intent of the attacker is
I
true.
agree. I'm asking you guys to think a bit critically about intent.
And I think in the real world, I used to be on the big distinction between voluntary and involuntary, but I've talked with some, and I've thought about it, and Abner's right. You really can't, and it isn't an element of a law, because the mere fact that somebody's using shields of any sort is the illegality. So you're not targeting the shields. Conceptually, you're going after the person who's doing it. And I think when we talk about feasible, that's another one of those undefined sort of things, and it never will be defined. But in the real world, this is what would go on. Number one, they'd start looking at means and method. Can we use a small diameter bomb? Can we use a drone? We're not going to use artillery, or something like that. And then they'll make a hard judgment. Okay, we're going to get all kinds of hell for attacking this target. So, do we really need to do it? And those evaluations really do take place. It doesn't mean that the attack's not going to take place, because it comes down to, if we don't get that guy, we don't know what he is going to go out and do other things. I think that when you think about human shields, and you asked about proportionality, what I tried to express, and I am alone on this, by the way, because I think the DoD evaluation is the best way to protect civilians is to not incentivize the use of human shields. I think that there is a reasonable minds can differ, that no, the best way of protecting human shields is to apply the proportionality analysis. I do think reasonable people can differ on that, because I think in most instances, you're going to be right. But when you start thinking strategically, you could come up with scenarios where this use of human shields would be so pervasive that you're dictating your own defeat, and that's not the way IHL is intended to work. So in my little brain, and it is smaller than most of yours, I think that when you're trying to make this proportionality decision, if your aim is to deny the enemy this means and method of warfare, then that will affect your proportionality analysis. In other words, how many civilian. But if your purpose is simply to punish the enemy, that's an unlawful purpose. Because that's, that is what judicial forums do. You're trying to punish from a war crime? No, you don't do that. And it's different from reprisal, because reprisal is to stop the enemy from doing it, but it's conceptually different than, because you're not, in reprisal, you're really not concerned about proportionality in the same way. They have proportionality, but it's a different kind of proportionality. So, in essence, I'm trying to split the baby.
You just didn't talk about proportionality.
Well, I mean, a civilian is a civilian, and I think, as I said, I think it's very hard to tell whether someone's voluntary, involuntary, unwitting, completely unaware of the fact that, they're possibly being used as human shield, and, it's not in the law. The difference is either you're a civilian or you're a civilian directly participating in hostilities, in which case you can be targeted for such time that you're directly participating. Otherwise, you can't be directly attacked. I mean, yes, proportionality will enter into it if shields are being used to protect an extremely, valuable military objective that would offer, tremendous military advantage. Then, you can't say, under all circumstances it would be, it would be disproportionate. I think almost all commanders, when they see an objective that's surrounded by civilians, would think very carefully before proceeding with an attack. Whether
Well, you do that evaluation all the time, knowing that some civilians are going to be killed, but it doesn't really matter if they're voluntary or involuntary, because you're going to go through that analysis. But when you know the enemy is specifically doing it, it does change the calculation.
There's a question.
I had a quick question for Abner. So I'm not a legal scholar, so it would be really helpful if you could clarify this for me, which is not clear in my mind. So let's say that we agree that the involuntary use of human shields is illegal. And I want to still preserve some space for voluntary, but that's a different issue. And now the law has certain ways to address the situation in which human shields are being used, such as the precautions, the proportionality, etc. that you mentioned. It's built into the law. I'm curious, what about the other way around? When the attacker alleges human shields, but in fact it doesn't correspond to reality, what are the provisos built into the law to prevent that? Because otherwise it seems that maybe I'm misunderstanding something, but there is a lot of provisions in the case that it's used, but in the case that it's used as a justification, it seems like there is nothing, or maybe I don't know, to prevent that.
But the justification is just rhetoric, and it's not, as far as I'm concerned, the attacking party, it's not for them to concern themselves about whether the defending party is committing the war crime of shielding. To me, it does not change the fact that these people are civilians, and you have to take the necessary feasible precautions, and they should be counted as quote unquote ordinary civilians in any proportionality calculus. And if you knowingly launch a disproportionate attack, that is a war crime. That's the consequence to the attacking party.
But doesn't it have the repercussion that in some ways it renders the defender responsible for the ensuing civilian deaths? I think that was part of
law. That is
right.
The law.
So
but I think this is what you're getting at.
About the inverse.
Yeah. What does the commander need to know? The standard in international law is what would a reasonable commander understand under those particular circumstances. And that's not any different than criminal law in other circumstances, or law generally. For example, in the military, it's a criminal offense to negligently kill somebody. For example, if you give under military law, if you give your car keys to somebody who you knew or reasonably should have known was going to be drunk and they kill somebody, you're guilty of homicide, negligent homicide. So but it's done from the point in which the commander makes the decision, not from hindsight when you turn out, oh my God, it was a hospital.
Right,
It's based on doing what a reasonable commander would do under the circumstances. And that's an unsatisfactory answer. And I'll tell you what my problem with that is, the difficulty is. Well, to what extent do you have to do extraordinary things that may be possible to do, but not practical to do or very costly to do? Do you send special forces up there where they have to fight their way in and then fight their way out to put eyes on the target? You know, these are real questions that are asked. And there is no cookbook answer, even though a lot of commanders want a cookbook. And the human condition is such that you have to sit there and bring to bear everything you know and make the best decision you can. But the end has to be, especially where human shield's concerned, what is the best way of protecting civilians? The manual text provision is, don't let them get away with using human shields. But the other view is that, no, just keep with the proportionality analysis in all circumstances the same way. And I've tried to split the baby in a kind of inarticulate way.
Could I ask a quick follow-up on that? Because I find your answer really interesting. You refer to the commander.
The person ordering.
Yeah, okay. But what if, and this is what I'm gathering from Neva and Nicola's work earlier today, so to maybe bring that also into the discussion, what if it's not just the individual commander and his judgment, but what if there's a whole machinery that renders this kind of utilization of human shield, the allegation of human shielding, a systematic strategy? Like
a trope during the entire attack on Gaza that was used at all
right,
levels.
so what if maybe the commander knows full well that there is no particular shielding at that site, but nonetheless because of the systematic
It doesn't matter what his
strategy-
government says or what his government propaganda is, he has to do the right thing. Not only from a moral, ethical perspective, but from a legal perspective. And that sounds in the defense of, I was just obeying orders. And that's a very difficult defense and disfavored in modern. But the commander has to do the right thing. It doesn't matter what his government is saying.
Just quickly
Better than
on your
Bruce last-
point about
last
wanting to preserve the space for voluntary shields. I mean, my sense is that, what you are talking about in your article is and your presentation really, it's not human shields in the IHL sense. Rachel Corrie might be a secular saint, but she's not a human shield. She was protecting a civilian home. She wasn't being used to protect or herself volunteering to protect a military objective. Now, if you're talking about preserving a space for activists to surround, sites from which indiscriminate missiles are being fired at civilian population centers, yes, that's voluntary shields, but I don't get the sense that that's what you're talking about. You're talking about activists, peace activists, basically. So that's, it's a different thing.
But they're also being accused.
Yeah, no, of course, that's the.
But they're
that's
also
the rhetoric.
appropriating the language of human shields in order to, in combat zones, like in the case of the Kurdish activists,
Yeah.
for example. So, maybe Rachel, that's disputable, but what if it is? Then, and if they declare and publicly announce, in order to insert themselves precisely into this IHL discourse, then how do we deal with
If
that?
they are actually, voluntarily, unambiguously, voluntarily shielding, legitimate military objective, which, should, be targetable. They're still civilians, in my interpretation of IHL, but, it's more, they become akin to the munition factory worker, the truck, the driver
Direct
and, civilian contractors on a military base. They're knowingly putting themselves in harm's way. They can't be directly targeted, but, they're putting themselves in harm's way and, but they're still civilians.
Bruce,
Yeah,
last
this is
question.
last one. Most of your examples were, it was 5 Taliban meeting, even if there's people in there. If killing the 5 Taliban saved the 50 civilians that they otherwise would have killed. Okay, would your view change if it was combat as we more commonly know it? That is, combatants are all morally neutral. They're all, and it's not 5 Taliban who are planning to kill civilians, but 5 Taliban who are planning to attack an allied base. Okay, so you're not saving the civilians by killing them and killing the other civilians. You're protecting your own forces, which is legitimate, but it's no longer, you can no longer take the moral high ground and say, well, we have to kill them to save civilians. Say we have to kill them in order to protect our own troops, and and in doing so, we took out 20. So take out make it.
Sure.
Okay.
The way IHL works is that, I said IHL, I meant to say law of war. In the US, we don't like using humanitarian because it implies that war can be done in a humanitarian way. But the way the law of war is interpreted, you don't make that decision based on an individual attack, you look at the entire campaign. So in other words, if the campaign is to stop the Taliban from killing civilians, then the fact that in this particular instance, you're protecting the forces that are aiming to stop the Taliban from killing civilians, the fact that you are your forces are there for a reason. And, if they're protecting the forces is a legitimate a military objective. And so if they're using human shields to attack you, then, that brings up, the commander can't let his base fall. And that is an issue, like during Somalia. Remember, they had thousands of Somalis pushing women and children down towards the base, which was right down by the airport there. And they were trying to overrun the base. And if you've seen Black Hawk Down, you saw what they did to all the soldiers. And so it makes for a very, very difficult decision. But you do look at the campaign, not each individual attack. And the example that is classically used in law of war training is you conduct an attack that's a diversion. In other words, you never really intend to march to Baghdad that way. And so really your real attack is coming from, but it's still a legitimate military thing to do. It's a legitimate ruse, even though you're killing people that aren't directly going to affect.
No, I understand that. My question though is, the people you're killing are just simply combatants, not war criminals. So would that change your calculus?
No.
If they're just other combatants? Because the examples you used were strong because you said, well, if I kill these 5 Taliban, I've saved 100 civilians. What if you haven't saved 100 civilians, but you saved 5 American soldiers? You want to protect the American soldiers, but the question isn't, are you saving civilians, but is it worth killing 20 civilians?
You're
to save
trying
5
to,
Americans?
presumably, that the American soldiers are there to protect 320 million Americans. I mean, and that's what every combatant, and that's why the international law is ideologically neutral. So in other words, you look at, from a military perspective, that attack, and and if they're using human shields, you have to make.
Okay, so but then it doesn't matter whether they. I'm just picking on your example. Okay.
Which is
Doing this over dinner?
Yeah.
Yeah.
The concluding remark is that there are no concluding remarks because we have to move and go to dinner, which is at the Brown Faculty Club. So
Let's meet in 10 minutes down at the door downstairs. People can go to the bathroom, smoke a cigarette, whatever people
10
do.
minutes, yeah.
And in 10 minutes, we'll meet in the front door.
You're not allowed to say smoke a cigarette anymore.
So thank you very much. Yes, thank you
You're not in the
very much.
Middle East.
Anyone that's
Listen,
interested-
thank you guys.
Yeah.
You guys.